Hi, my name is David Fraser. I'm an Internet and privacy lawyer with McGinnis Cooper and author of the Canadian Privacy Law blog. The purpose for this video is to let you know a little bit about Bill C30, the Protecting Children from Internet Predators Act, tell you how it's broken, and suggest how it could be fixed. Though this may be ultimately addressing a real problem that law enforcement agencies are experiencing, it's a bad law that, at least in my view, is based on a faulty premise. So the purpose of this video is to provide concise information. There's some details of the law that I won't have time to get into, but I think this should cover all of the salient information. So first of all, let's do a little bit of myth busting. Bill C30 doesn't give law enforcement warrantless access to your emails or your web surfing. As long as your email messages, your instant messages, things like that are considered to be private communications where you have a reasonable expectation of privacy, a warrant is always going to be required, or a production order. This bill is bad enough without having to make stuff up. So why lawful access? The police are telling us that they're dealing increasingly with criminals who are using technologies that can't be easily intercepted. They talk about the fact that wiretap laws and the current arrangement with telcos is based on a wireline industry, and increasingly people are using instant messages, BlackBerry messages and things like that can't be easily intercepted. They're also dealing with a volume of crimes where the only thing they know about the suspects are the IP addresses, or perhaps a phone number and an unlisted phone number. And so law enforcement wants to make sure they can facilitate lawful intercepts and make it easier to get access to subscriber information. Now, this law, or this bill, is not new. We have seen it introduced by both the Liberals and the Conservatives a number of times. In none of those times has it actually proceeded to be passed or ultimately voted on. In every single case, up until the most recent one, it's fallen off the order paper when Parliament has been prorogued or Parliament has risen. So the Liberals in November 2005 introduced the Modernization of Investigative Techniques Act, known as Bill C-74. The Conservatives then, in March 2010, introduced Investigating and Preventing Criminal Electronic Communications Act, which was Bill C-52. And now we're talking about a bill introduced by the Conservatives in February of 2012 called the Protecting Children from Internet Predators Act, Bill C-30. So what does Bill C-30 do? In a nutshell, it provides police with access to telco customer information without a warrant. It would give them access to, on demand, the name of the telco customer, the address of the telco customer, the telephone number of the telco customer, the email address and the IP address of the telco customer, and what they call local service provider identifiers that are associated with the subscriber's service and equipment. What the law also does is it requires telecommunications companies and telecommunications service providers to make sure that all of their equipment for the provision of telecommunications services to their customers are wiretap ready. This will require, probably in many cases, building in backdoors into otherwise secure systems to allow significant numbers of lawfully authorized, with a warrant, intercepts at any time and at a moment's notice. Now, this video is principally about the customer name and address information. I may have an opportunity to do a video on the lawful intercept provisions that will be required of telcos. So, let's talk about this customer information provision. So, what the law provides, and this is in section 16 of the bill, it says a designated person can demand, in writing, customer information. Now, a designated person is an agent of CSIS, an officer of a police service, or an agent of the Commissioner of Competition. So the limitations on the ability of these designated individuals to demand customer information is in 16 sub 2 of Bill C30. It says a designated person must ensure that he or she makes a request under subsection 1 only in performing, as the case may be, a duty or function of the Canadian Security Intelligence Service under the Canadian Security Intelligence Service Act, of a police service, including any related to the enforcement of any laws of Canada, of a province, or a foreign jurisdiction, or of the Commissioner of Competition under the Competition Act. Notably, it doesn't say shall not or shall only. All it says is that they have to ensure that their request is connected with these functions. I would also note that police services is incredibly broad and probably includes enforcing parking tickets and other extremely minor infractions. It certainly would cover intelligence gathering for law enforcement, and I think it's also notable that it refers to enforcing laws of a foreign jurisdiction. Now, employees designated by the following persons can make ordinary requests. The Commissioner of the RCMP designates people within the RCMP, the Director of CSIS designates people within CSIS, the Commissioner of Competition designates people within the Bureau of Competition, and the chief or head of a police service in a province can designate within his or her police service. Now, it says that the designated people can be the greater of 5 or 5% of all of the employees. Now, all employees would not be limited to just the sworn law enforcement officers. The RCMP has a significant number of civilian employees, so does the Commissioner of Competition, and so do many police bureaus. So I'm not sure that this limitation amounts to a significant limitation. The bill also says that any police officer can demand that information in the event of an emergency at any time. So it's not just limited to those designated people. They have to believe on reasonable grounds that the urgency of the situation is such that the request cannot, with reasonable diligence, be made under that subsection, under the subsection dealing with designated individuals and written requests. And the officer believes on reasonable grounds that the information requested is immediately necessary to prevent an unlawful act that would cause serious harm to any person or to property, and the information directly concerns either the person who would perform the act that is likely to cause harm, or is the victim or intended victim of the harm. So let's talk about what sort of information they get. So this provides police with access to telco customer information without a warrant. If they provide a written request by a designated person, or in the event of an emergency, here's the laundry list of data points that they can get. They'll get the name of the customer, the address of the customer, any email addresses associated with the customer, telephone numbers, IP address, and local service provider information related to the communications devices that they have. Now, it needs to be noted that they can demand this without limitation, and any one data point will lead to the other. So for example, the police can come up with an IP address and say, we want the customer name, we want the customer address, we want the email address that you have for the customer, and any information about local service sets. It means that they could come up with a name and say, hey telco, we would like the IP address that this customer has been using. There's not a limitation that each request be limited to one individual. Any one request, they could have a laundry list of IP addresses and demand customer name and address information. They could have a laundry list of email addresses seeking IP addresses and customer name and address information. There really isn't any limitation on that. Proponents of the Act have talked about increased accountability. Well, there's only increased accountability because currently there is none, but the accountability that's provided for in the bill is really inadequate. So what it says is the officer must create and retain a record to justify every single request. It then says that the information that's requested can only be used for those purposes or for compatible purposes. Well, those purposes can be writ very large, and then really what is a compatible purpose is staggeringly broad. It does say that once those records are created, they're subject to mandatory internal audits and reports of those audits to the responsible minister. That would be the minister who introduced the legislation, and the applicable privacy commissioner. Now in the case of CSIS, that goes to CERC, which is the oversight organization for CSIS, rather than to a commissioner. There isn't any public accountability. None of these records become public. None of these audits necessarily become public unless those ministers choose to make them public. And there are also gag orders contained in the legislation so that the telcos can't advise the customers that anybody has made these requests. A customer whose information is requested, even if it proves to be a dead end, even if it proves that ultimately the person is not a suspect of any crime, will never know that such a request has been made. The only time that they will find out is if it is introduced as evidence in a trial subsequently, where it's disclosed to them in connection with the prosecution. Innocent people that are caught in some sort of a dragnet or a fishing expedition will never know that their information has been obtained this way. So what's the big deal? Aren't we just talking about phone book information? And don't we have a low expectation of privacy in that sort of information? I don't think that's the case, so not so fast. You expose your IP address on a daily basis every time you use the internet. With every website you visit, there is likely a log created that identifies the IP address of either the computer you are using or your home router that's logged and kept. You also expose your IP address every time you connect to another person's computer using Skype or other peer-to-peer communications. In some cases, some instant messaging clients will disclose your IP address to the computer you're connecting to. Every time you share a file using a peer-to-peer communication system like BitTorrent, you are exposing your IP address not only to somebody downloading a file off your computer, but you are exposing your IP address to every single computer that wants to look for that particular file, whether they download it or not. We have an expectation that you can generally be anonymous online, since only your internet service provider is able to make the connection between your personal identity and your IP address. You are able to read news sites, you're able to comment on stories on news sites, you're able to voice your political opinion, you're able to sign petitions, you're able to send emails anonymously, which should be done safe in the knowledge that your identity will not be revealed unless there is a clearly compelling public interest to do so. That can be a legitimate law enforcement investigation, that could be a legitimate national security investigation, that could be in the event of suspected defamation or otherwise. But unless those circumstances are applicable, nobody knows the websites you visit, and nobody can connect at those websites your IP address with your personal identity unless a court tells otherwise. So is this phone book information? We're just talking about a customer name and a customer address and a customer phone number. No, I don't think so. Your name and your phone number appear in the phone book in a very different context. People can choose if they're going to be listed in a phone book, and it's a limited amount of information. Your name appearing in the phone book just tells the world at large that you have a phone. That is not particularly interesting information. The phone book is simply just an alphabetical list of customers of a telco. Now, your name associated with an IP address, particularly in the context that the police are looking for it, is not devoid of context. The police are specifically looking to connect you with some sort of unlawful act, or looking to connect you with something they are investigating. So to say that it's just like the phone book is, at least in my view, disingenuous crap. They're looking to connect individuals with their activities online. They're looking to make that connection. And at least in my view, that connection should not be made unless there is a very compelling public interest in doing so. So what are the limitations? One might say, well, surely this is restricted to significant crimes or significant investigations. No, absolutely not. This is only limited to the designated people performing their functions of the police, of CSIS, or the Competition Bureau. That can be the most minor crimes. That can be collecting parking tickets. So it's not just child exploitation. It's not just going after internet predators. It's not just kidnapping or harassment. So this can include parking tickets, as I mentioned, intelligence gathering. It can also include copyright infringement. The only reference to internet predators in the statute is in its title, which is, in my view, misleading. So could this be used for fishing expeditions? At least in my view, absolutely. There are no restrictions in the circumstances in which these powers can be used except in connection with policing and the functions of CSIS or the functions of the Competition Bureau. The police can demand, for example, the customer names for 100 IP addresses, 1,000 IP addresses, 10,000 IP addresses. All they have to do is create some paperwork, which is extremely minor. They can ask for the IP addresses of thousands of customer names. So for example, they could say, hey, John Smith is a suspect in something. We're going to go to the telcos and we're going to say, can you give us his IP address? And then we will start trolling around. And in fact, they can connect to that person's computer and discover, for example, what ports are open, whether they use Skype, whether they use BitTorrent or otherwise. And the police could also demand the email addresses for thousands of customers. All it takes is a written request. They can demand all of this information in unlimited quantities, and the only limit will be the budget of the police departments, because the police have to pay for the information. Now, how much they have to pay will be set in the regulations that nobody has seen. So, don't the audits protect us? No, not really. So the police say that this has an enhanced accountability, but at least in my view, this is currently a smokescreen. There's no requirement whatsoever that the police officer justify seeking the information. It only has to be related to his or her duties. And it's only after the fact that there's accountability. It's only afterwards that internal audits will take place to supervise the police how they do their jobs. It's not third-party oversight. It's not external oversight in any sort of way, even though privacy commissioners are entitled to inquire into this. And there's no obligation to notify the individual if no charges are brought. After the fact, actually, there's a gag order. So what's the problem? At least in my view, the right to privacy that we have includes the right to be anonymous, and this bill takes that away, at least with respect to the internet. In my view, that right to be anonymous should only be taken away and should only be curtailed if it's justifiable in the circumstances. In my view, the police aren't in the position to properly balance those privacy interests. In fact, the police who are advocating for Bill C30, such as the Canadian Association of Chiefs of Police, expressly say you don't have a privacy interest in your name and your address and your IP address. They're saying you have no expectation of privacy in this stuff, which tells me that absolutely they're not in a position to balance this at all. There are no limits on how these powers can be used, and there are no limits on how broadly this net can be cast. The accountability mechanism, at least in my view, is absolutely useless. So where am I coming from? What is my position on this? At least in my view, the police should not be able to require anybody to provide information about an individual in the absence of reasonable grounds to believe that the information either is or will lead to evidence of a serious crime that has been, is being, or will be committed, and the appropriate checks and balances are in place. So what about the police arguments in favor of all this? The police say that internet service providers are inconsistent in responding to warrantless requests, and I'm not surprised. They don't have the power to require this. It is entirely at the discretion of the internet service provider, and internet service providers have different standards of providing this sort of information. They also say that internet service providers take too long in responding to these warrantless requests, which really isn't surprising. This is not their core business in providing this sort of information. In fact, when the police come knocking and they ask for this information without a warrant, they're in fact asking those telcos to do them a favor. And the police also say that internet service providers sometimes don't provide the info at all because they don't have a warrant. Well, at least to me, that's not surprising. The police currently are not in a position to demand this information unless they have a warrant. At least in my view, they should go get a warrant. So what about the argument? Well, certainly they should have to go get a warrant for this stuff, and the police and the Canadian Association of Chiefs of Police say warrants take too long. Warrants take too much effort. And also, and this is surprising, well, I suppose it's not really surprising, but it's dispiriting, the police say in many cases they want the information in circumstances where they would not be able to get a warrant. Well, let's think about that for a minute. So they go knocking on the door of a telecommunications service provider or an internet service provider, and they say, give us this information. Well, if they would not be able to convince a judge to issue what's called a production order in those circumstances, that would mean they don't have reasonable grounds to believe that the request would lead to evidence of a crime that has been or is being committed. If they couldn't convince a judge that that information should be handed over, they absolutely should not expect that they should be able to get the information in the first place. So how do we fix this? How do we fix this warrantless provision related to customer address, IP addresses, names, and that sort of stuff? Well, the criminal code already has a mechanism that can compel telecommunications providers, and in fact any third party, to hand over customer information where it can be justified to a judge. These are called production orders. In section 487.012 of the Criminal Code of Canada, a judge or a justice can require a third party to hand over customer information on the basis of an ex parte application, so that's an application by the police alone, based on information provided under oath, so a sworn statement by the police officer saying that there are reasonable grounds to believe that an offense against the criminal code or another federal act has been or is suspected to have been committed. The documents or data will afford evidence respecting the commission of the offense, and the person who is the subject of the order, in this case the internet service provider, has possession or control of the documents or data. Now, let's break that down a little bit. So this is limited to actual real offenses, not fishing expeditions, but actual offenses. I think it's worth fixing this by adding the provisions offenses that will be or are being committed. There also has to be, at least in my view, actual evidence about the offense. This shouldn't be used for a fishing expedition. So if the police say that warrants are too hard to get, the way that we fix this without sacrificing the privacy of all Canadians is to provide more resources for more judges who will review police demands for this sort of information and make sure on our behalf that these requests are justified. Also, if they take too long to get, streamline the process, but don't throw judicial oversight out simply for efficiency or convenience. To put it very simply, if the police can't convince a judge that the connection between an IP address and an individual, i.e. a suspect, should be made, they should not be able to obtain it. If you can't convince a judge that it will lead to evidence of a crime, then the cops should have to go back to the drawing board. At least in my view, that such a change would fix the most offensive aspects of Bill C30, which is that, as it's currently cast, any designated officers for any policing purpose can require an internet service provider to make the connection between your online identity and your actual identity. As we go on the internet today, we have an expectation that it's only in circumstances where a judge has approved making that connection that connection will be made. And in fact, I think that it shouldn't be up to the whim of the internet service providers to decide whether or not in particular circumstances they're going to make that connection. It should be only up to a judge who can order that internet service provider to hand over that information so that connection can be made. So thank you very much for taking the time to listen to this. I would welcome any comments that you may have below, and hopefully I'll have an opportunity to answer as many of them as I can. Thank you.